Hi guys, welcome to my next MondAI BAIgel episode. I have a fabulous guest today. It's Joachim Steinberg. He's counsel at Crowell Moring, working on the intersection of tech, IP, and privacy laws. Joachim, it's great you could join me today.
Thanks so much for having me on.
We discussed a lot about European rules of IP protection and AI. And now we are here to discuss the US approach to copyright protection, IP protection, and AI. Let's start from explaining the legal implications of use of copyrighted materials to train LLMs. This is one of the major questions and a lot of disputes in the US.
Sure. I think this is, from a copyright perspective, one of the two big disputes. I'll talk a little more about more general questions later, but I think the first big dispute that's on everyone's mind is whether you can obtain a copyright in material made by AI, and if it's human directed and partially uses AI, to what extent you can get copyright protection. I think the second question is, to what extent is the use of copyrighted materials in the training data for generative AI infringing upon the copyrights held by those materials? I think that both of these are open questions. I don't think there's a good answer quite yet, but those are what practitioners are currently most interested in finding out the answer to.
Yeah, we discussed it in Europe too. Maybe you can share your views or maybe majority's views. Is there any or office's views?
So there's very little law in this, as you would expect. Things are still winding their way through the courts. Full disclosure, I'm one of the lead litigators in the Thomson Reuters v. Ross litigation, which is going to trial in August, which involves allegations of the use of copyrighted material in a legal technology program. We think it was not infringing. We also think there's a fair use defense. That's you can read that decision if you'd like. There are other cases winding their way through the courts right now. I think the defendants, particularly OpenAI, have done a very good job of fending off those claims for now. I don't think there's a majority view yet. I just don't think there's a meaningful consensus around this. And I think there's a few different ideas floating around. There's ideas that, look, any use in a training program has to be infringing. You've copied the data at some point, you're benefiting from it, that's an infringing use. I think there's another view that because of the way AI works, unless it accidentally pushes out the exact same image you pushed in, it's by its nature transformative. And so this has to be fair use, and at best you've got intermediate copying. I think there's a third view that regardless of what happens with this question, the way we can solve this is with a mechanical licensing scheme, the same way we do for a lot of different forms of intellectual property, including sound recording rights. So I don't think there's a meaningful consensus. I certainly don't think there's anyone who right now, other than litigants and cases, would say this is definitively the right answer. And given the early days of generative AI that we're in, that's probably for the best.
So can you explain in more details what the law says, how the law works in the US? It's slightly different from European rules.
Sure. So we have a doctrine that exists in a certain extent in Europe, but very differently, called the fair use doctrine. If you read the copyright statute, fair use is not an infringement. But in practice, in the way courts analyze fair use problems, often courts just assume your use infringes, but it's okay for these other reasons. So there are a number of factors that people look at in terms of whether or not your use of it is fair, whether you escape liability on the basis of it being fair use. One is the purpose and character of the use. Second is the nature of the copyrighted work. Third is amount and substantiality of the portion used. And the fourth is the effect upon the potential market. And courts balance these in different ways. We've had a bunch of litigation determining it. Really, a lot of fair use doctrine and a lot of what is going to happen, I suspect, in the AI world as AI becomes more and more advanced are questions of transformation and market effect. So are you just using AI to replace something on the market, or are you truly coming up with a different product that happens to rely on other AI uses?
So can you go even more into details, how do you apply all these factors to AI, to LLMs? Why do you find it is fair use, or why do you defend this position?
Well, I think a lot of it really comes down to transformation. For example, I could walk into a museum and look at all of the Impressionist paintings, and if I had any artistic talent whatsoever, go home and paint an Impressionist painting. And as long as I didn't make something substantially similar to an existing Impressionist painting, I have not infringed anyone's copyright. I don't know that there's a principal difference between that and what AI does, taking those images, creating something else, except I suddenly don't need to have the talent to actually paint it, and maybe someone else needs to code it. Now, maybe there's a principal distinction. I haven't heard that one yet. Similarly, when you think about other major advances in technology, things like photography, there was lines of thought early days of photography that this was completely mechanical. There was no human interaction whatsoever. And what we found is that's not true. I don't think anyone sits around thinking that like Canon owns the copyright in every photograph taken with a camera they've made, even though that significantly lowered the barrier for entry for instance, landscapes or portraiture for which you used to have paintings. And so I think really that question of transformation and really the question of where the human input is coming is going to be a major question. I think this has to be balanced against other elements of intellectual property law in the United States. Most of the technology, at least right now, is fairly closed off. It's kept as trade secret, probably appropriately, and so you don't necessarily have an easy way to separate out what the human creativity is, what the human is doing relative to what the AI is doing.
Mhm.
And that creates a real open question for copyright, I think. But the standard for copyright for creativity in the United States is extremely low. Unlike Europe, we have very few references to moral rights in works in our copyright law, both as a matter of statute and constitutional law. And as a result, the questions are a little bit different, I think, than some of the ones that are asked in Europe.
Okay. So how do you think these disputes end? Is it a new regulation that is awaited, or copyright offices find a solution, or you await final judgments of, let's say, Supreme Court in one of the big cases?
You know, historically, fair use has been a matter of case law. It's been decided by the Supreme Court, and it's established by statute, but most of the major developments have been either the circuit courts or the Supreme Court of the United States. We had a recent decision in the Andy Warhol case. I think it's very much an open question in United States law about whether or not Congress is going to feel the need to regulate, whether the Copyright Office is going to issue guidances around fair use in particular, and how long that will take relative to what the courts do. I think if people are being intellectually honest, the kind of open question is, do we need a new regulatory regime, or is existing copyright law sufficient to handle this? And I don't think there's an intellectually rigorous answer on one side of those questions yet. I would be very suspicious of anyone staking out a strong position on how we should regulate AI right now.
I fully agree. In Europe, we have a new directive on IP rights, and it's new, but it's from 2019, and it's a bit old. So I would advise to wait how AI develops, generative AI develops, and then act, regulate.
That's right. I served on a round table with an MEP on this recently, whose complaint, which I think will sound also familiar to Americans, is that legislative bodies are not necessarily the most technically adept places in the world, and so you are sort of hoping that the legislatures have staff members who really get it and really understand what's going on.
Mm-hmm.
I do think there's been, at least in the United States, a kind of general sense among our politicians that with social media, with big data, and with the internet, they didn't really get ahead of things. They were caught sort of off guard by some of the transformative effects of new technologies, and they very much don't want to do that now. But I don't know that's a good reason to jump right in 2 feet in the AI stuff.
I would like to discuss the second open question. What about outputs? tools they are when we use generative AI in our daily job? How should we protect ourselves while working in the US? What's your advice?
So the existing state of the law is that anything made with generative AI, it cannot be copyrighted. You need human interaction. And to the extent you use AI in creating something, you can't get a copyright in the portion that AI made.
Mm-hmm. What does it mean in details? Because in Europe we have a discussion
So,
of how big human impact should be.
right. So, for instance, you know, if I ask AI to make me a photo of looking at the San Francisco Bay, which is right outside my window right now, and then I take the photo and I print it and I use wax paper, print, whatever, however I want to modify it, I'll only get a copyright in the stuff I've actually done to that output. So I can obtain a copyright, but it'll be relatively thin. And it will only be in the stuff that a human definitively did. I think this guidance was premature. And I think the reason it was premature is that it seems very likely to me that if it's not happening now, it will be in 6 months, and that there are almost certainly in many commercially available artistic software suites technologies that are either clearly generative AI or will be considered part of generative AI in use now without people really knowing it.
Right.
So if you use like a photo editing software, I think it's almost certainly that almost every commercially available photo editor in the next 5 years is going to use some form of something we consider AI to do rudimentary effects. I don't know that that's really realistic for people to be disclosing that use or sorting out what part of that is human and what part is not. And again, it goes back to the analogy of a camera. You know, or for instance, a film student going to their professor and saying, I want to make this character seem ominous. And the professor saying, well, you should use a Dutch frame, and then doing it. Like the fact that the tool you've used to accomplish it to AI does not strike me as sufficient reason to say it's not creative and not part of human input. Where that line is going to be very difficult to sort out. Now, the Copyright Office released this guidance, but then asked for comments. They received, I believe, 10,000 comments. That was the number that was being thrown around. I think they ordinarily receive like 15 comments on a thing. So people are certainly paying attention to this, and people are going to be involved in this debate very heavily. But I do think, again, it's very hard for someone to have an intellectually honest, complete view of this, especially right now, and especially not knowing what AI tech is going to look like 2 years from now. And so I appreciate the direct question, what do I think? But the thing I tell everyone is keep an open mind and be willing to listen to different things on specifically the authorship question.
My final question would be what is the approach of US lawyers, IP lawyers or privacy law lawyers toward AI? Do you see any change of approach? I discussed a lot these matters last year, and there was a huge hype on AI. And has it changed?
You know, from a client counseling perspective, at least to my mind, it hasn't changed. We deal with novel issues all the time. That's really the thing you should be paying lawyers for, is the issue no one's seen before, where we have to deal in uncertainty. And so in that sense, it's just another novel issue that that lawyers have to approach. In another sense, I think, to go back to something I've talked about a little bit, I think there is a divide among lawyers between those who think the existing regime is fine and those who think we're going to need to really come up with a new regulatory approach to this. But from the client counseling perspective, it really is a matter of focusing on what your clients need and assessing a reasonable map to get there. There's just more uncertainty than usual because it's such new technology. So I hate to give the answer most clients hate, which is it depends. But look, it depends. For some of my clients, there are concerns about intellectual property. For others, the concerns are really privacy and cybersecurity driven, and they both have very different approaches to AI or to even how they want to deploy it. And so, really, I think the job hasn't changed, but a lot of us have become a lot more familiar with a much more wide-ranging tech than maybe we were prepared to be a couple of years ago.
Yeah, I agree. As a researcher, I'm really pleased to this change. As a practicing lawyer, I'm also really pleased because we have more and more work to do. Joachim, thank you for being here. Thank you for interesting discussion. Good luck in your dispute. Of course, I my fingers crossed. And thank you.
And thanks again for having me. It was great to talk.
It was great to talk to you. And you guys, join my next episode. It will be also such an interesting